All right, it is now about 1 minute after the hour, so I think we can get started now. Welcome everyone who's tuning in, and thank you all for joining us today. On behalf of Biotech Canada, we're thrilled to feature two experts from the law firm Norton Fulbright for a virtual session on employment and labor in the time of COVID-19. So Heather Cameron and Chantal Arsenault will be touching on topics relating to employment, labor, workforce concerns, and layoffs, work shortages, that sort of thing. So before you begin, I'd like to bring the attendees' attention to the Q&A feature down at the bottom of the screen. So if you bring your mouse down, you'll see a Q&A button. You can type in your questions there when we get to our question period. If you have any questions, you can type them in during the presentation, but we probably won't answer them until the end of the session. So with that, I will mute myself and turn off my video and hand it over to Heather and Chantal. Go ahead.
Great. Well, thank you very much, Emily, and thank you everyone for joining us today. We want to leave enough time for questions, so I think we'll skip right through the introduction and get to the content. And the purpose of this presentation, I think, is to go through a bit of the most common questions and hot topics that we're getting about employment in the COVID-19 context. As I'm sure everyone would expect, these change on an almost daily basis. So we're going to try and be a bit, I think, you know, both past, present, and a little bit perspective today if we can as well. So depending on the workplace, a number of workers still have employees who are working on site. Those in essential services or those who are in sort of essential roles may be on site. And the most sort of common questions we're getting around this is, what do we need to be doing to protect people? What if somebody refuses to work? And those questions are becoming more popular as people are starting to look towards the return to work. You know, as provinces are talking about lifting restrictions and as we're getting people back on, back into the work site, what do I do as an employer if an employee says, I'm not coming in, I'm not ready to return, or I don't think it's safe to return, or I'm not coming in? And so both sort of present and future looking, I think that work, it has to be exercised reasonably, and employers still have the obligation to manage risks or eliminate hazards, depending on the wording of the applicable legislation where you are, but really that focus to sort of take active steps to make sure that the workplace is safe. And what we've seen with COVID-19 is that it is quite fluid. A lot of things people haven't thought of before, but there are some best practices you can put in both now and in future as the restrictions lift. I think the main takeaway would be for employers to take their guidance from public health on this point. It's difficult for people now to sort of predict what that might look like, but if you're acting in line and within best practices with public health, you will be able to reduce some of the risk, and you'll be able to assure your employees that, we have thought about this. Some of the tips and tricks, which you would expect would be the social distancing to continue in the workplace. Anybody who doesn't need to be there if they're able to work from home, they can continue to work from home. Things like staggering shifts, instead of having everyone work 9 to 5, some people work 7 to 3, some people work 8 to 4, some people work 9 to 5, some people work 10 to 6 maybe, and things like lunch breaks or common areas would be spread out over their shifts as well. There's physical changes people can make to the workplace in terms of looking at how, desks are set up, how much space is there between cubicles, how much space is there, how many meetings are you doing in person, how many meetings can you do over the phone, that kind of thing can reduce risk. And then of course, the trying to find rare bottles of hand sanitizer and making that available to everyone. And then the other thing I would say is you want to just listen to the employees' concerns, because they may think of something that employers haven't. And the goal here really is to keep everyone healthy and safe. So I think at this point, many employees, and in some workplaces, all employees are working from home. And the most common questions we've been getting about that have really dealt with the sort of workplace setup in something like a home office. People, in terms of the right to refuse unsafe work in this section, people have been asking, well, what do I need to do for my employees? Do I need to inspect every work site? That's not feasible. How do I make sure people are, set up for success? And there's a few tips and tricks that you can do for this as well. Arguably, there isn't an obligation on employers in this context to review every work site and to make it sure it's safe, but to do your best to help employees mitigate risks. You can circulate, for example, one of the pamphlets or the bulletins that tell people how to set up their work sites so that everything's at the right angle, so that tripping hazards are removed, and then have that sort of open dialogue with employees. Do you have the equipment you need to do your job? Is there something you're missing? Is there something that, is there something that we need to provide? And then to figure out how to make those arrangements. And if somebody calls in and says, look, I got a bad back, I need to get my ergonomic chair from the office, to make the arrangements for people to access that information or to access that equipment. And then to also, some people may need to come to the office from time to time, for example, to use a scanner or some other equipment, and to have a bit of a protocol in place for how that works that still respects social distancing requirements. And then what I would say as well for employers is that you'll want to make sure that you remind people that even though you're working from home, if you're dealing with confidential information, private information, anything intellectual property, that those protocols still stand. Employees who are working with confidential information will need to make sure that, that your laptop should still be password protected. Confidential information shouldn't be accessible to anyone else. I mean, nobody's really working in a coffee shop or restaurant at this point, but that still doesn't mean that information should be sort of freely lying around. And what a lot of employers can do is, if you have a policy from a work from home or telework type arrangement that you use sort of on a case-by-case basis before the pandemic, that can be adapted for employees to sort of say, a reminder that, while you're working from home, the expectation is that you will respect privacy, or that any equipment you take home would have to be returned, or, we're not responsible for damage to this, that, or the other. That kind of information that you would normally have in a policy like that can certainly be adapted and extended for this sort of context. But I would say, generally speaking, there wouldn't be an obligation to inspect every work site. It would just be more of a proactive question. Do you have what you need to work safely? And if you have any concerns, please bring them to your manager's attention, and we can sort of work through them together. And then in terms of managing the risks, if employees need to come to the work site, it's a lot of the same that we were discussing before. If you think you'll have a lot of employees who are coming into the work site from time to time, one way to handle those requests is to have everyone sort of run their requests through a central person, so that person has an idea of who's going to be there when, so that if there is a problem where you say, realistically, we can't have that many people in there, people may sort of need to come into the workforce or work site by appointment only. And that's certainly something you can do. Or you could have sort of one person gathers the mail and scans it to everyone, instead of everyone coming in to get their own mail. And then you encourage people while they're there to, wash their hands, don't use the communal kitchen, wipe down sort of any mess you make. If you're using common touch surfaces, maybe you wipe them down when you're done, or you wipe them down when you get there, and provide the cleaning supplies people would need to do for that sort of thing. It really will be a case-by-case assessment based on what your workplace looks like, but just thinking about it, thankfully, a lot of it does come down to common sense. And if you're like me and you've been reading as much of the repeated news articles as I have, you probably already have a very good idea of what public health is recommending. So before everyone gets bored of my voice, I'll flip it over to Chantal to weigh in on temporary foreign workers.
Thank you, Heather. Yes, we thought we would talk a little bit about temporary foreign workers in the context of both what's happening at the workplace and the back to work that is going to happen slowly but surely. I know there has been another session on immigration, so we're not going to dwell too much on it or spend too much time on it, but it may not be the same people that are online right now. A few reminders. So first, when we're talking about temporary foreign workers, we're talking about individuals who are currently in Canada working for you with a temporary work permit. Temporary work permits therefore have an expiry date that is attached to them. In the context of COVID-19, although there are some adjustments that have been made by the government for some of the rules, it doesn't include the right to remain in Canada without making sure that the status is appropriate and that is current. So it's very important for your workers that are in Canada to be sure to renew their work permit if they are about to expire. So it is possible right now to file application online. The service is still available. You may run into some issues where if the individual has to undergo fingerprints, for example, it won't be possible to do those fingerprints because all of the offices are closed. But the mere fact of filing an application to renew is enough to give status to the employee. We call that implied status. So even if they haven't received a response from Immigration Canada, if they have filed their application for renewal prior to the expiry of the work permit, you know that they're covered, they're allowed to continue to work, and you as an employer are also covered to make sure that the individual is working legally in Canada. A couple of other questions because things are going to start up again working. We're looking at the temporary foreign workers that you want to bring to Canada from the United States and from any other countries that the United States. So as you are probably well aware, there are a number of travel bans that have been implemented since the beginning of COVID-19. So in terms of employees coming from the United States, what the current travel ban says, it says that people from the United States cannot come to Canada for reasons that would be optional or discretionary. So working is not considered as being optional or discretionary. So in theory, individuals coming from the United States are allowed to come to Canada to obtain their work permit, for example, at the border or open entry into Canada. So that's what the rule says. Sadly, in practice, it seems that some of the officers at the port of entry or at the airports have added a criteria of essential work in order to allow the work permit to be issued. It should not be there. It's not part of the regulations, but that's what we're seeing in the field. So it's a good idea if you do have somebody that needs to come from the United States that you explain the essential nature of the work, the fact that it's not discretionary or optional, but it is important for the individual to come to Canada, and be prepared to face some hurdles. So I would say that if it's not necessary or if it's not mandatory for this person to come for your work, you may want to wait until the bans are lifted. At this point for the United States, the ban is in force until May 21st. Of course, we can see what is going to happen after that. Situation is a little bit more difficult when we're talking about individuals that would need to come to Canada to work, but from countries, any other countries in the United States. The ban is stricter on that one. So you will be able to get your employees that already have work permits to come back into Canada showing their work permit, or you would be able to get your employees that have received an approval from an embassy or a consulate for the work permit. The difficulty there is that filing an application abroad, most offices, either the consulates are closed, so you can file an application online, but you cannot do the fingerprints. You cannot, in a lot of cases, do the medical exam. And so we haven't seen any approvals from these other countries and the United States right now since the pandemic started, or at least since the travel ban started. So that's a more difficult situation, except if we're talking about urgent and essential work for medical workers, for example, or things like that. And then the last point is just a quick reminder about the quarantine period. So the quarantine period is mandatory for anybody entering Canada, including your current employees, whether they're Canadian or they're foreign workers. So be prepared to have them quarantine for 14 days. And the quarantine period has to be established before the individual comes. So you have to make sure that the individual can come, can find a place to quarantine for 14 days, does not have to stop shopping for food, for example. So all of that is organized. Otherwise, they may be quarantined at a location that is decided by the authority. There are only a few cases where the quarantine period is not required. And this is really essential work. And so the threshold for that is much higher than just the work to come into Canada. We are talking about, for example, truck drivers or people that have movement, people in the health frontline situation that would need to get working right away, or things like urgent repairs and so on and so forth. So there's not a whole lot of exemptions. So you have, again, to be prepared. If you want to have somebody that comes and you want to have the quarantine period waived, you really have to prepare for those submissions and this explanation for your workers to come in and get started right away. That would be it for now. I'm going to let Heather keep talking about other issues as well, and I'll come back for a few questions.
Perfect. So it shouldn't surprise anyone, I don't think, that a lot of the questions we get as well deal with layoffs, temporary or permanent layoffs, reduced work weeks, and then from our end, whether or not that gives rise to a constructive dismissal. So if you're considering layoffs or a reduced work week, but we'll look at sort of layoffs first, there are, before, like pre-pandemic, I'll say, the law was quite settled that even though each statute or legislation allows an employer to lay someone off for a temporary period without it constituting a termination of employment under the legislation, courts would actually look at whether the person had a term in their contract or a collective agreement, or whether it was sort of common in the industry and in the business that these layoffs would happen. And if you didn't have it in a contract, collective agreement, or an implied term based on industry experience, the legislation wouldn't save you, and there was a real risk that the employee would say, well, I've been constructively dismissed. And constructive dismissal happens when, instead of terminating somebody, you've changed the terms of their contract by such a fundamental and substantial amount, and done it on a unilateral basis, so without their consent, that they're basically entitled to say, this isn't the deal I signed up for, and in the case of a layoff, the deal was I work in exchange for pay, and if you don't have work and you don't have pay, then I don't really work for you anymore. It's no different than having terminated my employment in the first place. And a successful constructive dismissal claim really comes down to, this is no different than if I'd just been terminated without cause, so I'm entitled to all the damages that I would have been entitled to had I been terminated without cause. The same idea works for sort of a reduced work week or reduced pay. Pre-pandemic, the understanding was generally, if you cut pay by 5%, total change in total comp of 5%, usually not a problem. 10%, it's getting a bit iffy. Anything more than 10%, you're really looking at that sort of constructive dismissal piece. And I say pre-pandemic because what we have seen, not to encourage people to sort of engage in mass layoffs, but what we have seen is layoffs have become much more common. Reduced work weeks or reduced compensation has become much more common. And employees have actually been pretty understanding about it, thankfully. And the reason I mention that is that a lot of employers are saying, I don't have a choice. either my supply chain's being interrupted or my business, my clients are gone, or I can't find people to do the work, whatever it might be. There's a lot of employers who are saying, we've been ordered to close down. I don't have a choice. We have to lay people off temporarily, or we have to reduce work weeks, or we have to cut pay. And is it true? Can I do it or can I not? And generally what I would say is that employees have been pretty good about it. Everyone's been somewhat understanding. I think the key there is that, this is not the time to target underperformers. If there's no work for a department, then the department gets laid off, and everyone in the department seems to be pretty understanding so far, knock on wood, that they're going to be recalled when all of this is over. And employees who are recalled and are happy to be back at work aren't the type of employees who sue. But if you use the opportunity to sort of pick on one or two people who have been a thorn in your side for a while, those employees are more likely to sue. So that's a bit of the framework in terms of what to do when there's not enough work. And then sort of superimposed on that has been, widely covered in the news, all the government benefits and programs. So I've captured sort of the three about which we seem to get the most questions: the work sharing, the emergency wage subsidy, and the emergency response benefit. There are quite a number of other programs and bailouts, subsidies, whatever you want to call it. Our firm actually does have a guide on its website about the available programs if anyone wants to consult it, but for these purposes we'll focus on the three. And so the work sharing program is a government program that allows you, when you have a shortage of work, to distribute it between employees. So instead of working 5 days a week, employees work 2.5 days a week each, and then they're normally on EI for those extra 2.5 days. The reason I wanted to bring this up is that a lot of people see it and say, that seems like a great idea, I'm just going to implement that. And the trick with the work sharing program is that you actually can't do it on your own. You need the employee's consent, and you need the government's approval to put in a work sharing relationship. So the change that the government has made is that a work sharing relationship or arrangement can now last a lot longer, but you still have to apply in the same way, and you still have to have the employee's consent. And the government will call employees to verify that they have in fact consented. So it's a great option for anyone who's willing and able to do the legwork, but it's not salvation for everyone. The emergency wage subsidy is probably more detail than we could possibly go into here, but that's the one that provides up to 75% or about $850 roughly reimbursement essentially of employee wages. And the big question we're getting around that, I won't get into all the sort of tax qualifications or eligibility criteria, but the questions we're getting around that, there's been a lot of, well, I have laid people off. If I bring them back, am I eligible for the wage subsidy? And you can be. The government has been clear that their sort of goal with that is to get people off layoff, get people back to work, get people back on payroll. And if there isn't work for people to do, that's okay. If the emergency wage subsidy allows you to pay people 75% or more of their sort of pre-pandemic earnings to sit at home, that is something that we've thought about, and we're okay with it. The CERB, or the emergency response benefit, is different. That's the replacement for EI. It's the $2,000 every 4 weeks that gets paid directly to employees. Employees can't be eligible for the wage subsidy and the emergency response benefit in the same period of time. But what's helpful for employers to know is that if you have employees who are working part-time up to sort of $1,000 in earnings for that 4-week period, they can still be eligible for the CERB. So that program is out there if you're looking at, what to do when you don't have enough work, but you recognize your employees have bills to pay. I'll turn it back to you, Chantal.
Yep. Thank you. I just wanted to add a few things regarding temporary foreign workers, because we have been getting a lot of questions regarding those benefits. So typically, pre-COVID, if you want, somebody that has a work permit that is an open work permit. So by open, it means that the employee has a work permit that does not have a specific employer name to it. So those individuals, when they were laid off or fired or lost their job, could technically have access to unemployment insurance because they were available to work, having an open work permit. For those who had closed work permits, so closed meaning that the name of the employer is on the actual work permit, it was more of a challenge for individuals to get benefits after, because technically they're not available to work for another employer, given that the work permit doesn't provide them the right to work for another employer. So they were often denied benefits for government benefits like employment insurance. With COVID, what has been decided is that, particularly when we're talking about the CERB, it has been confirmed that even if individuals are on a closed work permit, they have access to those benefits. So it's important to realize that because some employers were coming to us and indicating, what if I lay off this temporary foreign worker? Does that mean the person is in the street with no way to have any compensation? And thankfully now it's there. So that's one of the questions we got often. The other aspect is when we're talking about layoffs, when we're talking about reducing work weeks or salary, we have to remember what impact it would have on employers who have used the temporary foreign worker programs. So when you hire a temporary foreign worker that is on a closed work permit, so your name is attached to the work permit, you've made some promises to the government saying, we're going to pay this individual that salary, there's going to be X amount of hours, this person's going to work for this duration. And so this is an obligation that employer has to respect, and there's always a possibility of having what is called a compliance review, and that's when the government is knocking at your door and saying, hey, you made those promises, now prove to me that you respected your obligation if you want to be able to continue to use the program. And those compliance reviews are not rare. They happen for 1 in every 4 employees using the program. So over time, most employers do get at least 1 compliance review. So how does that impact the employer when we have situations like the current one? The government has a certain level of flexibility, and they understand that there may be a reason for changing those conditions. In non-COVID situation, an employer would have to advise ahead of time the authority that there is going to be changes to the condition of the foreign workers' employment. They have, in the case where a labor market impact assessment has been requested, so they have clearly indicated that they don't need to be advised that some adjustment can be made given the circumstances. But we have to be careful as employers when we do that. One, you want to make sure that you keep good notes of the entire situation, because if you do get a compliance review 2-3 years from now and it's a different person that isn't in charge of your HR and doesn't quite know what has happened, it is going to be more difficult to respond to a compliance review. So you want the files to be clear about what is happening. And it is very important that the measures that are taken across the board and are not targeting temporary foreign workers. A little bit in line with what Heather said, that it's not time to get rid of an employee that is a troublemaker. It's not time to just diminish the job of 1 temporary foreign workers and everybody else is doing the same, or all your temporary foreign workers are cut, but everybody else isn't, because then you could be found non-compliant as an employer. And that can have consequences that are both monetary, so you can have a fine for that, but you could be seen as not able to use the temporary foreign worker program, so not being able to hire temporary foreign workers for an extended period of time, and certainly you want to avoid that.
Thank you. Okay, so this will take us somewhat, I guess, full circle almost to our first slide when we were talking about the people returning to work and working from home. The other question that we're getting is now, it happened when people started working from home, and it's happening when people are sort of putting feelers out about the return, is employees saying that they're not able or willing or to either keep working or to come home or to return to the office. And what I generally tell employers in that situation is have a conversation with the employee to figure out why. There are a number of reasons. So, as long as the daycare centers and schools remain closed, there will be a lot of employees who may not be able to either return to work or be able to sort of work the same hours that they were working from home because they have child or elder care obligations. And those are protected under family status rules under most human rights legislation. Obviously, I say those are protected. We don't have any case law on this yet, but I would expect that if, based on the case law sort of pre-pandemic, because taking care of a child outside of school or an elderly relative or person for whom you are responsible for sort of the necessaries of life, that kind of legal obligation would trigger family status accommodation. So an employee who's saying, I can't come back to work, or I can't work the hours that I would normally work because I have, small children at home, and, this is my schedule and this is what's going on, would be entitled to some form of accommodation and couldn't be punished or disciplined in any way for those requests. The other piece is the statutory leaves. I'm not sure the jurisdiction in which everyone on this call operates, but a number of provinces have passed legislation. In Ontario, it's called declared emergency leave. And as long as the government of Ontario has a declared emergency in place, employees are entitled to a statutory protected leave. So it is, they continue to accrue a seniority. They continue to be entitled to participate in the benefits plan. They can't be terminated because of this request for leave as long as the emergency continues, but the leave is unpaid. So if an employee says, I can't come back to work because either I'm COVID positive, or I'm in quarantine, or I have, childcare obligations is another one. In Ontario, they may qualify for declared emergency leave. And as long as there's a declared emergency, they can be on unpaid leave, and at which point they would probably apply for the emergency response benefits. So in terms of managing those requests, either if it's a refuse to return or a request for time off, I would say dig a little bit deeper, figure out what the reason is, figure out first whether you have a legal obligation to provide that time off or to give somebody what they're requesting, but manage those requests on a case-by-case basis, looking at sort of each request on its own. And for human rights accommodation, it would only be if you reach the point of undue hardship that those could be refused. And a statutory leave, you could be in violation of the Employment Standards Act or comparable legislation if the employee were denied that leave or punished in any way for requesting to take it.
And the last little point here that I wanted to add that as an immigration content to it is when we're talking about employees unable to return to Canada. So as I indicated at the beginning, individuals who currently have work permits are allowed to travel back to Canada. There has been a period of time where they were not allowed, so it took some time before the rules were set straight for employees that have work permits but were traveling and when the travel bans were imposed. But the reality is that it is difficult for a lot of people, even though on paper they're allowed to come back, for them to re-enter the country. I have an employee from a company that we're trying to get back. It has been now for the last 5 weeks, or actually really since the entire pandemic, because they were gone for a period of time, and we were looking at our options to get them back. In theory, they're supposed to come back today. I haven't heard yet, so I'm crossing my fingers. But the reality is it's difficult. Even if they are allowed to come back, they have to first face difficulties in finding flights, because as we all know, there's a lot less flights for people to travel back to Canada. And in able to get on that flight, they have to convince the airline attendants that are looking at their tickets that they're allowed to board that flight. So that's an added difficulty. And they also have to convince the officer upon arrival in Canada that is correct and they can enter. So it's a lot more difficult than in normal times to travel to Canada, even though when we look strictly at the rules, they are able to come. There's also difficulties sometimes to travel back with their family members. So you need to get some authorizations in some of the cases, which again, will make it more difficult for them to come back. So a little bit like Heather is saying, you have to dig down a little bit more to make sure that it is reasonable on the part of the employee. But if they're saying, I'm stuck outside of Canada, we have to start with the idea that these are in good faith and they do want to come back, but they may have some issues to coming back. And one last thing is, as we know, if anybody is experiencing symptoms, they will not be allowed on the flight, even if they have the proper documentation. So once again, that can delay their return back to Canada, because then they would be requested to quarantine for a 14-day period. So it's not an easy time. We have to look at situations that we haven't seen. We say that for us, but that's the reality even for the people applying those new laws or those orders. So it's very difficult and uneven in terms of the application. So as employers, we have to make sure that we do get the full story before we assume that it's just somebody that simply doesn't want to return to Canada. That would be it for me. I don't know if Heather, you had anything else you wanted to add on this issue?
No, I think in terms of just a final thought though, I mean, to the extent that employers are counting on flexibility and understanding from employees in terms of reduced work weeks, I think employers have to be, flexible and understanding as well if someone's not able to return. So that's it for us. We're happy to open it up for question, and I guess Emily, you'll be back to help us out with that.
Yes, I'm back. Here I am. So all the guests who are viewing right now, if anyone has any questions, please go ahead and find that Q&A feature. Oh, I see one just popped in right now. First question, do either of you have a sense as to how insurers are managing group plans and sick leave?
Sorry, was the question how insurance companies are managing like sick leave related to COVID-19? Sorry, there was a bit of a feedback. Yeah.
Oh, sorry. Yeah, I think so, yeah.
Yeah, my understanding is from an employment lawyer's perspective, so not a disability claims adjudicator, but my understanding is that most insurance companies are treating COVID-19 as a sick leave, like as a compensable sort of disability under something like a sick leave or a short-term disability policy. That would be conditional on the employee presumably having a positive test or a presumptive positive test. An employee who says, I can't work because I have childcare obligations is not going to qualify for benefits, but an employee who can't work because they're ill or quarantined, I think most insurance companies are recognizing that as a short-term disability. I would encourage everyone though to check with your own insurance company and check the terms of your insurance contract before telling employees that it's covered, because it may not be in every case.
Okay, thank you. All right, any other questions before we wrap up from the audience? If you're looking for the chat feature, you can hover your mouse down to the bottom of the screen and you'll see a gray menu pop up. Give it one more minute.
And I think we can say here is if Emily, you get any questions from the participants, and because people think about it after, or people cannot find the right button to ask their questions, which sometimes happen to me, we're happy to answer the questions via email. So you could, Emily could send it to us. And on our website for Norton Rose Fulbright, we do have a very comprehensive section on COVID-19, every subject that or questions that we've received. So there's a lot of information there, and there's also a general address to send us on COVID-19 question. When they do get those questions, they forward it to the right person. So if it's an immigration question, it'll come to me, employment and labor, Heather, or some of our colleagues. So we're happy to answer any questions that may come later.
Great. Well, thanks so much, Chantal, for that. That's helpful because actually I haven't seen any other questions come in. So either you did a very good job answering everything, or else maybe we just have a shyer group today. So
hopefully you're not going to say we confused everybody. So that's
well, you confused me. It sounded very crystal clear to me. So thank you again so much for your taking the time today to be with us, and I hope all of our companies who have tuned in are able to get something out of that. And now, President and CEO of Biotech Canada, Andrew Casey, I'm going to let him, there he is, speak here for a moment. I think he wants to give you a bit of a thanks.
Can I be heard?
You can be heard.
Okay. Heather and Chantal.
Oh. Sorry, Andrew.
Sorry, I got dropped. Now I'm there?
You're there now as a panelist, so you can turn your video on if you want.
Oh, okay.
Yeah.
Let's do that. There we go. Hey, Heather and Chantal, thanks so much for that. It's a really comprehensive overview of what's a very complex area. As you indicated in your opening remarks, Heather, obviously very quickly moving and shifting. And so some of the insights that you provided on a number of those areas are super helpful. I think there's some sensitivities there, so there may be some shyness for that reason, but also we will put this up on our website so others may just sort of tune in later and follow along what you had sort of laid out and may have questions coming from that going forward. And I suspect there will be, because as this thing changes and evolves, more and more questions are going to come up related to HR issues. I think what we've seen to this point is most companies are sort of hanging in there. They're making do. They've got enough runway with the cash on hand that they can keep people going. Some of the labs have been able to be kept open because they're deemed essential. But the longer this draws out, I think we're going to start to run into some more challenges, certainly from an HR standpoint. And so I think this kind of advice is super important from that aspect. And we may come back to maybe go through what's evolved over the next couple of weeks, because it is evolving so rapidly. I think back to when this first started, and it was very hard to predict what was going to happen in 5 days. Now it feels like I couldn't tell you what tomorrow is going to look like. And so in this particular space, I think there's some complexities and obviously some real risks. So the advice you gave today was incredibly helpful, and we really appreciate your expertise. And if you can let us tap into you again at some point in time down the road, that would be also very helpful.
Certainly, with pleasure.
Thank you.
Absolutely.
Good. All right. Well, with that, thanks again, Chantal and Heather. I guess I will end the meeting now for everyone.
Thank you.
Great.
Okay,
Thanks, everyone.
Thank you.